Now I hope this full screen is visible to you.
Professor Sunil Goyal,
So
friends,
welcome you once again
PhD coursework
to this
being conducted by
topic
New Law
on
College,
infringement and enforcement of. So the goal of preparing this learning module which is on infringement and enforcement of copyright. This is an humble attempt made by me to increase your awareness about the copyright, awareness about the infringement and enforcement of copyright in the global research enterprise. And the objective of this presentation is to let you understand the need, let you understand the importance of copyright while pursuing research in legal studies. And I hope after going through this learning module you will be able to understand the importance of copyright, you will be able to understand the definitions of copyrights and copyright infringement and enforcement also. So friends, about what is copyright, then we will go further with talking about what is meant by copywriting work, how this copyright actually works, copyright versus trademarks and patents, because you see how this copyright is different from trademarks, how this copyright is different from patents, what is copyright infringement, and what are how you understand what is the concept behind this copyright infringement, what are the issues of copyright. We'll see one real world example also of copyright infringement, followed by what are the national legislations concerning enforcement of copyright, followed by some questions which we will discuss the answers, followed by conclusion and the list of articles, resources if you want to have some more understanding on infringement and enforcement of copyright, followed by references for the readings. Let us start today's presentation on what is meant by copyright. You might be seeing this symbol very often when you come across with the books, when you come across with the literature, when you come across with the literary work, all rights reserved. What is meant by copyright? First we'll try to understand what is meant by copyright. Copyright, actually the copyright it is a statutory or common law protection being granted to a literary work, and this gives owner of the creator, owner of that particular work which a person claims to be original one, this copyright gives him exclusive right to reproduce the work. And copyright refers to the legal right, because this copyright is a legal right of the owner of the intellectual property. In simpler terms, copyright is the right to copy. This means what? This means that original creator of products, or original creator which gives authorization to anyone else, they are the only ones with the exclusive right to reproduce that particular work. And this copyright law, when we are talking about, this gives creators of original material the exclusive right to further use and duplicate further use and duplicate what? Further use and duplicate that material for a given amount of time, at which point the copyrighted item becomes public domain. This is what is actually meant by copyrighted. This is what is actually meant by copyright when we are talking about the copyright. Because you see, this law is a big service. Law is a big service based business, and business, finance, taxation, litigation, corporate affairs, conflicts, patents, copyrights, antitrust, you see, property, labor, arbitration you can include, as well as you see administrative, political, social matters. These all requires law expertise. And there are, you see, there are other criteria to rank law firms. Several criteria are there, for example, revenue per partner, revenue per lawyer, or not the number of lawyers, or year over, you see the percentage growth, annual revenues. There are several things when we talk about, you see, when we are talking about the law. And when you see, when we speak about giving the authorization means what? Giving the authorization means what? Means there is an agreement. Licensing agreement. Licensing agreement means legal, written contract. Written contract between two or more parties, wherein the property owners gives permission to another party to use their brand, their patent, their trademarks, and their own creative work. And the agreement, you see, which is set between the licensor. Licensor means the owner of that particular material, and the licensee. Licensee means the permitted party. Contains details of the type of licensing agreement, the terms of uses, how that licensor is to be compensated. This all, you see, this all is there when we are talking about you see, anyone they gives authorization, because we are talking about, if we are authorizing anyone else, means what? Means this. And you see, this copyright law protect creators of original material from unauthorized duplication or use. And for an copyright take place, when someone creating, copyright is what? Copyright is for creating a product. Copyright is for creating a material. When someone creates a product that is viewed as the original one, or that requires significant mental activity to create, this product becomes an intellectual property that must be protected from unauthorized duplication. Because you see, this is my original creation, and this should not be duplicated by others. This should not be copied by others. And this copyright actually provides me exclusive rights for this. For example, unique creations. Unique creations include computer software. For example, art, poetry, graphic designs. You see, musical lyrics, compositions, novels, films, original architectural designs, website content, etc., etc. And one safeguard, that can be used to legally protect an original creation is the copyright itself. And under this copyright law, a work is considered original. You can consider this work original if the author himself has created it. What is meant by author himself has created means, this means he or she has created from independent thinking, void of duplication. This means like this. And this type of work, you see, is known as an original work of authorship, OWA. This is original work of authorship. And anyone with an original work of authorship, OWA, automatically has the copyright to that work, preventing anyone else from using or replicating it. The copyright can be registered voluntarily. You see, I have used this word voluntary. It is not compulsory. It can be registered voluntarily by the original author, original owner, original creator, if they would like to get an upper hand in the legal system in the event that the need arises. But my dear friends, learned ladies and gentlemen, not all types of work can be copyrighted. A copyright does not protect ideas. A copyright does not protect discoveries. Copyright does not protect concept, does not protect theories. Brand names, logos, slogans, domain names and titles also cannot be protected under copyright laws. This is the provision given. You can't because you see, when you are talking about brand identity describes the externally visible elements of a brand that identify and distinguish that particular brand in consumer's mind. And this can include, visual aspects. This can include visual aspects such as color. This can include visual aspects such as design, such as logo. It can also include, the type of language, the interaction a brand has with the consumers, with its customers. And not only this, when we are talking about, business essentials, when we are talking about, these logos, because it has mentioned logos, slogans, domain names, titles. This cannot be protected under copyright. And for an original work to be copyrighted, it has to be in tangible form. This means that speech, this means that discoveries, this means that musical scores, ideas have to be written down in physical form in order to be protected by copyright. This means like this, my dear friends. Now going further, what is meant by copyright? Let us have a, because when we have already spoken about, trademarks, patents. What is copyright versus trademarks and patents? And we are talking about this copyright. It is not all encompassing. Other laws such as, patents, such as trademark laws, they may impose additional sanctions also. Although copyright, although trademarks, patents are frequently used interchangeably, they offer different forms of protection for intellectual property. And when we are talking about, we are talking about trademarks, when we are talking about, patents. Trademark, you are all aware about this. Trademark is a recognizable sign. Trademark is a recognizable phrase or a symbol, actually, which denotes a product, which denotes a service. And this legally differentiates it from all others of its kind. And this trademark exclusively identifies a product as belonging to a particular company, as belonging to a particular corporation. And it recognizes the company's ownership of the brand. And trademarks are considered as a form of intellectual property. And these trademarks are, they not only help distinguish products within the legal and business system, but just as significantly with consumers, they are used to identify and protect words, they are used to identify and protect design elements that identifies the source, that identifies the owners, that identifies the developer of a particular product or particular service. They can be corporate logos, they can be corporate slogans, or the brand name of a product. And similarly, my dear friends, when we are talking about patents, you all know patent is a legal document. It is a legal document which gives the holder exclusive intellectual property rights over a specific invention. And patents are an important element in encouraging innovation. And this patent is is the granting of a property right by a federal authority to an inventor. This grant provides the inventor exclusive rights to be patented process, exclusive right to be patented design, to be patented invention for a designated period in exchange for a comprehensive disclosure of the invention. And they are a form of incorporeal right. And government agencies are involved in this. They typically handle and approve applications for patents. And as already, trademark laws protect material that is used to distinguish an individual's or corporation's work from another entity. Trademark includes words, phrases, symbols such as logos, slogans, brand name, which copyright laws do not cover. That's why there is a difference between copyright and trademark. Patents, as already said, invention for a limited period of time. Patented material include products. Patented material include products such as industrial processes, machines, chemical positions. This is what is actually the difference between copyright, trademark, and patents. going further, my dear friends, what is copyright infringement? Now let us talk about what is meant by copyright infringement. You see, copyright infringement means what? What do you mean by copyright infringement? What is actually copyright infringement? Copyright infringement is the use of production of copyright protected material without the permission of the copyright holder. When anyone else use or produce a copyrighted protected material without taking due permission of the copyright holder, this comes under copyright infringement. And copyright infringement mean by third party? Because you see here we will talking about are being breached by third party. Third party means what? Third party means here an individual or an entity that is involved in a transaction but is not one of the principals and thus may have a lesser interest in the transaction. A collection agency may be another example of third party. And these third parties work on behalf of one or more individuals involved in the transaction. And one more term we have used here is contingent liability. What is this contingent liability? Infringement cases may lead to contingent liability. What is it? What are some examples of contingent liability? Because you see, when we are talking about contingent liability actually is a liability that may occur depending on the outcome of an uncertain future event. Contingent liabilities are recorded if the contingency is likely and the amount of the liability can be reasonably estimated. And this, you see, when we are talking about the liability, this liability may be disclosed in a footnote on a financial statement unless both conditions are not met. And this, you see, when we are talking about contingent liability, my dear friends, a contingent liability is a potential liability that may occur in the future, such as pending lawsuits or honoring product warranties. This contingent liability is likely to occur and the amount can be reasonably estimated. The liability should be recorded in the, accounting records of a firm, accounting records of the company. And these contingent liabilities, my dear friends, when we are talking about this, in reference to copyright, contingent liabilities are recorded to ensure that the financial statements are accurate. And these financial statements should meet requirement of generally accepted accounting principles also. This is what is I mean to say by contingent liabilities. And copyright infringement actually is an infringement of copyright to do any type of work with copyrighted content, copying it, issuing copies of it to the public. When you issue copies to the public, this also comes under copyright infringement without taking due permission of the creator, of the owner, renting or lending it to the public, performing or showing it to the public, communicating it to the public. This all comes under, you see, copyright infringement. And in cases of copyright infringement, a copyright owner can seek civil remedies as well as he can file a criminal complaint also. Civil remedies like he or she can seek injunctions to prohibit further infringement. Civil remedy means delivering all infringing articles to the owner. This means right to seize copies of such infringing articles. It means recovering damages for loss from the account of the infringer's profits. This means like this. Now, going further, let us understand what is meant by copyright infringement. Because when we are talking about individuals, when we are talking about the companies who develop new work, who get themselves registered for copyright protection, to ensure that they can profit from their efforts, other parties may be granted permission to use those works. Those work through licensing arrangements, or they may purchase the work from the copyright holder also. However, there are several factors that may lead other parties also to engage in copyright infringement. Several factors, there are reasons. Reasons include high price for the authorized work. Why I should pay such a high price? Why I should buy that literary work or that product or that material from the copyright holder? Because you see, buying means it is very costly. Why to pay high price for authorized work or a lack of access to a supply of the authorized work? You see, when we are talking about copyright infringement, you see a worldwide acceptable, the most acceptable definition of copyright being given by United States Copyright Office. They have defined it, and this is accepted worldwide as a general matter. Copyright infringement occurs when a copyrighted work is reproduced, when a copyrighted work is distributed, when copyrighted work is performed, when it is publicly displayed, or even made into a derivative work. Very, very important word is being used. Made into a derivative work without the permission of the copyright owner. This is what is meant by copyright infringement, my dear friends. And the Copyright Office this office doesn't actually prosecute those who violate copyright law. Copyright Office has nothing to do with this. But instead, Ministry of Law on the court cases and the necessary legal documents. They can assist. You can take assistance from the Ministry of Law. You can take assistance from the court. You can see the various court cases. You can file the necessary legal documents also. This is how you can understand this concept of copyright infringement. Now, coming to the various copyright infringement issues. What are the copyright infringement issues? Because you see, copyright infringement issues, they have varied over the years. But with the rapid, you see, advancement in the technology, in the techniques, in the tools, you see, this copyright office nowadays is facing a growing number of issues in an effort to keep pace with the innovation. Because there are several issues like technology. There are several issues like international issues. Issues like photography, issues like visual assets, issues like non-economic rights, issues like internet. Let us see all these issues one by one. Let us see. Number one is technology. What is this technology? Why this technology is an issue? As far as this copyright infringement is concerned, modern technology makes it relatively easy to copy a product, to copy an information. And by doing so, my dear friends, you know, some companies are deriving a substantial part of their revenue from replicating what other companies have created. This is what is happening. This is what the companies are doing. That's why technology is an issue. International, there are several international issues also. Copyright infringement and the resulting laws which are surrounding protection can vary from country to country, with different options. They have various options for recourse. They have various, options for different amount of the protection. And you see, in an international setting, when we are talking about, international setting, it is very difficult to prove copyright ownership. And the domestic courts, may see enforcement of copyright claims from international companies as a threat to national productivity. And some international organizations, such as European Union, they attempt to keep the regulations, they attempt to keep the enforcement guidelines of its member countries as harmonized as possible. Now they have come up with some common guidelines. Because this, when we are talking about European Union, because this European Union is a political and economic alliance of the countries, of the member countries. And why this EU is formed? EU is formed actually to promote democratic values. Democratic values in its member countries, in its member nations, and it is one of the world's most powerful trade blocs. And this European Union, my dear friends, they have grew out of a desire to strengthen strengthen political cooperation throughout the continent of Europe in the wake of the, you see, after World War II. And when we are talking about, you see, um, European Union, when we are talking about, you see, political and economic grouping of the countries which are committed in sharing democratic values, and you are aware of about this. The euro nowadays is a shared official currency among the various European Union countries, member countries. And in recent years also, European Union has expanded to include many of the other countries also that had been socialist states before the collapse of the Soviet Union. Photography, visual assets, with the advancement of, you see, digital imaginary, it has become easier than ever to copy an image. And over the past few years, the Copyright Office have been made aware of the various copyright issues from the photographers, from the illustrators, from the graphic artists also. Non-economic rights. This is because not for all copyright infringement result in a measurable monetary loss per se. Moral rights, my dear friends, are enforced as well, which covers these moral rights covers an author's right to be identified. Author's right to be identified as the author of the work, which is also called as right of attribution. And also authors look to prevent changes, prevent distortions of their work, called the right of integrity. It means you have to protect the right of attribution, you have to protect the right of integrity of the original creators also. Internet, growing importance of internet is there, and this internet is creating new obstacles for copyright holders also. Why? Because it is easier nowadays than ever before for copyrighted material to be accessed by the individuals, by the companies around the world, and the creation of new technologies. This has outpaced the regulatory environment's ability to ensure that copyrights apply to new formats also. These are the various issues which are to be addressed when we are talking about copyright infringement. Now, coming to our real world example of copyright infringement. See this real world example. From this real world example, you will be able to understand this issue of copyright more deeply. You can understand this issue with more clarity. For example, the music industry was caught off guard by the development of, you see, online music sharing websites such as xxx.com. You see, this is I have replaced the original name. xxx.com was an online music website that allowed peer-to-peer sharing of music files through their network. Please keep this in mind. Peer-to-peer service sharing of music files through their network. Peer-to-peer means P2P service. Because you see, P2P service, peer-to-peer service, this is a decentralized platform whereby you see two individuals interact directly with each other without intermediation by a third party. This is peer-to-peer sharing. And instead, the buyer and the seller, they transact directly with each other via this peer-to-peer sharing, P2P service, P2P sharing. And the P2P platform, this may provide services such as search, this may provide services such as screening, such as rating, such as payment processing, such as other things also. And there is no third party involved. And peer-to-peer platforms, you see, this is offering service such as payment processing also, such as information about buyers also, such as information about sellers also, such as quality assurance to the users also. Because this is a decentralized platform where two individuals interact directly with each other without intermediation of a third party. And this xxx.com was an online music website that allowed peer-to-peer sharing of music files through their network. And customers would share or distribute music of various artists for free. Record companies within the music industry sued this company called xxx.com for copyright infringement to protect their intellectual property and won their case. Protect their intellectual property means the intangibles owned and legally protected by a company from outside use and implementation without consent. And this concept, you see, because you see there is intellectual property, they want to protect their intellectual property. The companies, the record companies want to protect their intellectual property. And they have sued this company, music industry, sued this company xxx.com for copyright infringement in order to protect their intellectual property. Because you see, intellectual property is legally protected from outside use or implementation without consent. This is an intangible asset and is a non-physical asset also. And this, you see, when we are talking about intellectual property, the concept of intellectual property relates to the fact that certain products of, you see, human intellect should be afforded the same protective rights that applies to physical property called tangible assets. And this intellectual property is an umbrella term used for set of intangible assets or assets that aren't physical in nature. And intellectual property is owned. It is legally protected from outside use and implementation by a person or a company without consent. And that record companies now has sued this xxx.com for copyright infringement to protect their intellectual property, and they have won that case. And xxx.com was found in violation of copyright laws because, in part, the company knew the widespread distribution and did not do enough to stop it. And also, you see, this xxx.com, the music was copied and used by the customers, which was financially harmful to the record companies. And sale of their music is going down. And xxx.com was also found to have financially benefited at the expenses of these record companies by allowing the copy, by allowing the distribution of music. And companies seeking target for copyright infringement claims can also go after the companies providing the files, but could also seek damages from internet service providers also, as well as individual users also. This is what, friends, is meant by, you see, the infringement of copyright, the enforcement of copyright. Now coming to the national legislation concerning enforcement of right. You see, the availability of appropriate provisional conservatory measures is an indispensable element of any efficient mechanism for the enforcement of copyright. The most important objective of such measures are the prevention of acts of infringement and the seizure of infringing copies, reproducing equipments, and other implements that could be used for infringement, for further infringement, for that can be used for constitute essential evidence and could disappear if not brought under the control of the court. And these measures must be available on an ex parte basis, where giving the defendant prior notice would be counterproductive. This is you see, this is a concern of enforcement of rights as far as national legislation is concerned. And in particular, it should be possible for right owners to be granted temporarily preliminary injunctions to prohibit the committing, to prohibit the continuation of committing of infringement. Also, you see, my dear learned friends, courts must be able to order the search. Court must be able to order temporary seizures and temporary, you see, impounding of suspected unauthorized copies of work and other protected subject matter, packaging material, implements for the making of such copies, such documents, accounts, business papers relating to such copies. And the purpose of civil remedies, which we are talking about previously, the civil remedies, the purpose is to provide compensation for the prejudice caused by infringement. Civil remedies, the purpose behind is to provide compensation. The purpose behind is to dispose a appropriately of the infringing copies, typically through destruction or other disposal outside the normal channels of commerce. The purpose of civil remedy is to dispose appropriately of implements used for infringing activities and to grant injunctions to prohibit further infringement. And such remedies, when we are talking about, should always be available, irrespective of whether the infringement has been committed willfully or for profit making purposes. And you see, when we are talking about civil remedies, these civil remedies are not always sufficient deterrents. And where infringement becomes a business, the closing down of one plant with the assistance of the court of law, with the assistance of law enforcement authorities, may only mean that the plant will reopen somewhere else. An infringement committed willfully and for profit making purposes should be punished by criminal sanctions also. And the level of sanctions must make it clear that such infringement of copyright are serious offences. And it is normally preferable that criminal sanctions are also applicable in case of infringement committed through gross negligence for profit making purposes, because it may be difficult to prove that infringement are committed willfully. It is very difficult to prove that this company is willfully committing the infringement. And increased punishment in such cases of recidivism are justified. The criminal sanctions available should comprise both the fines and imprisonment, and where merited by the case, court should be able to impose both of these sanctions on the infringer. And in certain cases, the only practical means of preventing copying is through so-called copy protection or copy management systems. That is, systems containing technical devices. Because you see, nowadays, with the advent of technology, with the advancement of technology, systems have come into the place. And these systems containing technical devices that either entirely you can prevent the making of the copies or render the quality of copies made so poor that they are unusable. You can do this now with the advancement of technology. Now, you see, such things people are doing, companies are doing, and technical devices are also used to prevent the reception of encrypted commercial television programs, except with the help of decoders, which would be viewers have to buy or rent. However, my dear friends, it is technically possible, you see, to make devices by means of which copy protection, by means of which copy management system, as well as you see this encryption system, it may, although illegally, be circumvented. People are doing this, they have come into this play also. And where such devices are manufactured, such devices are imported, or such devices are distributed unlawfully, the normal exploitation of the work is undermined. and may cause serious prejudice to the authors of or other owners of copyright in those work. Such activities are violations of protection violation of protected rights and should be sanctioned in a way which is similar to that of other kinds of infringements. So friends, this is what is all about the national legislations concerning enforcement of copyright. Now, a question which is oftenly asked, why infringement is just like any other crime? Now uh, let us focus on this. Why it is considered? Why this infringement is considered as a crime, just like other crimes? Most of us, you and me also, love to download movies, because you see the question comes in our brain, in our mind, why to pay a hefty amount to sit in a theater? Why to go and watch movies which you can easily watch in the privacy of home? Why to go to theaters when you have a facility to watch that movie for free? And having said that, my dear friends, do you realize that you might be committing a serious crime that might even throw you in a jail? Because this misconception, the misconception of what is copyright, misconception of how this copyright work has been prevalent for a long time, and it's time we get our facts straight and start following the rules. We need to understand that, like photocopying, like downloading films, like songs too, is illegal. We have to understand this. And when authors, when musicians, and when other artists, they are continuously putting their creativity, they are devoting their, valuable time. That means it is not free for all. We must remember that the person has probably spent a lot of time, person has probably spent money to get it published. And we as users should respect that and get a proper license before using that particular art for free. And my dear friends, learned ladies and gentlemen, giving credit to the author, giving credit to artist, this is not only justified when his or her art form is fairly used. Any crime on our behalf can cause devastating loss. Devastating loss, maybe it driving under the influence or copyright infringement. And when you copy without consent, that means you reduce the hard work of the artist, you reduce the hard work of that particular musician, that particular filmmaker, that particular laureate, that particular publisher to nothing. And this too is a crime. This too is a crime, both under the table transactions and a blatant reproduction of original works are punishable by laws. Copyrights are the rights actually given by the law to the creator of literary, to the creator of dramatic, to the creator of musical and artistic works, and the producers of cinematograph films and sound recordings. And these include the rights of reproduction. These includes the rights of adaptation, rights of translation, rights of communication of the work to the public also. The scope and the duration of the protection provided varies with the nature of the protected work. And when we are talking about copyright infringement, in case of this copyright infringement, the offender can be penalized with imprisonment up to 3 years and or fines up to rupees 2 lakhs. Now the question is, are you still going to take the gamble? Friends, this is all about my today's presentation as far as copyright infringement, as far as enforcement of copyrights are concerned. Let us now go further, and let us now focus on to some questions which might be coming to your brain, which are coming to me also, because you see, the first and foremost question before me is, what is copyright? How can a copyright be protected? What is copyright? You see, again I am telling, copyright is a form of intellectual property. Copyright protects original literary, copyright protects dramatic, copyright protects musical, artistic works. Copyright protects layouts, copyright protects typographical arrangements of published work. Copyright protects sound recordings, copyright protects films and broadcast also. This copyright actually gives the creator of the work the exclusive right to copy, the exclusive right to give license, the exclusive right to give it on land, perform, show the work to the public, to make an adaptation of the work or to translate that particular work. This is an exclusive right provided to the creator of that work. And moral rights, they are similar to copyright. And this gives the creator the right to be identified as the author of the work. Not to have, you see, their work changed, and the right to object to derogatory treatment of their work. The main idea is that by giving authors the right to control the use of their work, they can make a living from it, and it will motivate to produce new work also. This is the main purpose behind, making this Copyright Act. And what makes copyright a complex mechanism is that it has to encourage learning and spread the knowledge while securing economic and personal rights. Economic and personal rights to authors, economic and personal rights to creators. And striking the correct balance is one of the major challenges of copyright law. Again, one more thing I am telling. Please remember that copyright does not protect ideas. Copyright protects expression of ideas that are fixed in a permanent form. Please see this, because idea cannot be copyrighted. You cannot protect the idea, but you can protect expression of ideas that are fixed in a permanent form. For example, written down or recorded form. It might be useful to mark your work with the copyright symbol, your name, the date of creation. But My dear friends, this is not necessary. This is not necessary because copyright arises automatically. There is no formality such as registration of copyright marks are required. But more by many researchers, how do I copyright my work? Is there a formal procedure? How can you copyright your work? Is there a formal procedure for getting your copyright, getting your work copyright? No, my dear friend, there is no formal registration procedure for copyright. As long as your work qualifies for copyright by being original, it obtains protection as soon as it is in a permanent or fixed form. And you see, when I am talking about originality means using your own skill. Originality means using your own labor, using your own judgment, using your own effort. What this means is that the work must not be copied from another work. It should originate from the author himself. And there are steps which you can take to help protect your copyright. For example, if you ask me the example, sir, how can I protect you? You could send it. You could send it to yourself by special delivery post and leave it sealed. With some types of work, such as scripts, such as photos, it can be sufficient to send it to yourself by email. There are also, you see, copyright services which are available, which also acts as a similar evidence. But however, nowadays this is not as relevant as it used to be, since the computer records the dating of production is almost always possible. One more question which often comes before me: can more than one person have copyright in something? Can copyright be owned by more than one person? Yes, my dear friends, the answer is yes. Works that are created by more than one person are generally considered to have joint ownership of the copyright. For example, if I can give a simple example to support my statement, the first copyright owner of the film are the producers, the principal director. In some cases, different people hold the copyright for different parts of the work. For example, a song can have copyright in its arrangement. Song can have copyright in its tune, lyrics, sound recording, the performance wise. If the music is packaged into the compact disc, the artwork can have a copyright. The copyright in this, you see, in this scenario, in this various elements can be owned by different people. Which often comes, how can I sell, how can I license my copyright? What is Creative Commons? Because this is a word which is sparingly used by others also. Because as the copyright owner in your work, you can sell, you can license it to others also, which could be done through a contractual agreement. Yes, you are free, you can sell, you can license your work to others through a contractual agreement. Some creators choose to join a collective society who then licenses and collects royalties on their behalf. Alternatively, uh, you see you have one more option, Creative Commons, because when we are talking about Creative Commons CC, which are licenses that explicitly actually encourage the free use of work. By distributing your work under a Creative Commons license, you will allow the public to reuse it for free. This should help the dissemination of your work. If you want to disseminate your knowledge, if you want to disseminate your art, if you want to disseminate your writings, literary work, if you want to disseminate your music free of cost, if you want to disseminate your art free of cost, you see this is a platform, Creative Commons, because it allows the public to reuse it for free, and this should help the dissemination of your work, and more generally the spread of knowledge, the spread of creativity is involved. You have the option now. Copyright. If someone infringes my copyright, what should be my course of action? What should I do? Very simple. Infringement of copyright occurs when someone takes either all of your work or a substantial part of it without permission. There are several exceptions which allow a copyright work to be used without permission. If someone has infringed your copyright, means you could contact them directly or consider mediation. First, I would like to suggest, please contact him directly, or you can consider some mediation also, or you can seek some legal advice also. If you decide to take legal action, there are a number of remedies you can seek from the court, which we have already discussed in detail. And friends, these all, I hope, now the concept of copyright infringement and enforcement is very clear to you. One more question which is often comes to me: can you take an image from the Google search? My dear friends, this question is very very important, because you see, there are, when you go to Google or when you are downloading some videos, there are copyright rules of YouTube also, there are copyright rules of the matter which is present on the Google also. You have to first seek permission from the copyright holder, unless your use falls within one of the exceptions, unless it is Creative Commons. Because you see, Google is simply a search engine that scans the internet, that provides the searcher with any relevant results, and copyright holders do not upload their images to Google for free use. If you click on the image, you are usually guided to the source website, where you might be able to contact the copyright holder for permission. My advice is to please do take prior permission while copying anything from the Google, because this Google is a search engine. It is not a platform for free distribution. These are all the things. One more question which is being asked to me by one of the students: what should I do if I receive a copyright infringement notice? How should I proceed after receiving the notice of copyright infringement? You see the textual content of the website. When you are going to a website, when you are copying something, when you are copying some content, and all this textual textual content which are available on the websites are being prepared by leading academicians and is intended to be accurate and authoritative. And whenever you receive a copyright infringement notice, my dear friends, better to go to a lawyer and take professional legal advice for that, so as to keep your interest saved. This is my humble suggestion, humble submission to everyone. Now coming to the concluding part of this learning module. As a general rule, first expressed in Baker v. Selden, copyright law seeks to protect the expression of the idea, not the idea itself. The work should be original, with the author having expended some creativity into it. The person with a copyright work is entitled to economic, pecuniary rights. These rights, granted by statute or judicial pronunciation, entitle the owner to exploit the work for economic gains. The owner is also entitled to moral rights to prohibit others from tampering with their original work. This cannot be assigned, and they guarantee the integrity of a creation despite any change in economic rights of the work. Friends, whatever I have prepared, whatever I have presented before you, this learning module is based on. You see, all these online resources I have referred to. I am thankful to the creators of all these content, the website creator, the website owners. So thankful. I am thankful to all these. You see the links, the matter which is available free of cost for reading. I have taken some notes from it, and I am so thankful to all these authors for making my concept so clear about the infringement and enforcement of copyright. Thanks to all these authors, and thanks to you for watching my presentation, my learning module on infringement and enforcement of